Some breaking news for any Indian taxpayer who has foreign assets or earns income from abroad. The government has just announced a major change, and honestly, it's going to offer some serious relief from what has been a huge source of anxiety for a lot of people. Here's the headline. The Central Board of Direct Taxes, or the CBDT, has quadrupled the threshold for starting a criminal prosecution over undisclosed foreign assets. Yeah, you heard that right, a 4x increase. This is a massive policy shift, and in this explainer, we're going to break down exactly what this means for you. Okay, so here's our game plan. We'll start with why this is such a big relief. Then, we'll do a quick dive into the law behind it all, the Black Money Act. After that, we'll get into the specifics of the new 20 lakh rupee rule, unpack the critical difference between a prosecution and a penalty, and then wrap it all up with a handy compliance checklist. So first up, let's talk about the big picture. This is a huge relief for taxpayers. Why? Because this change directly tackles the very real fear a lot of people had about making small, often accidental mistakes when declaring things they owned overseas. Think about it. Before this new rule, things were pretty intense. If you failed to report foreign assets worth just 5 lakh rupees, that's it, just 5 lakh, you could find yourself facing a criminal prosecution. That low threshold created so much stress, especially for people with maybe a small investment or a forgotten bank account abroad. Now, to really get why this new rule is such a game changer, we need to quickly understand the law that it's all based on. And that law is the Black Money Act of 2015. This is basically the government's main toolkit for tracking down undisclosed foreign income and assets held by us, the Indian taxpayers. It's a very serious law with a lot of teeth. So when we're talking about foreign assets in this context, we're talking specifically about what are called movable assets. This slide gives you some perfect examples, things like foreign bank accounts, stocks, mutual funds, or even employees' stock options. And what's just as important is what's not on this list. We're not talking about immovable property, like a house or a piece of land. All right, now for the main event, the new rule itself. Let's get into the numbers and see how this creates a much-needed safety net for taxpayers. This is where you can really see the difference. The old threshold for even thinking about starting a prosecution was a mere 5 lakh rupees. That has now jumped all the way up to 20 lakh rupees. That's a 4-fold increase, giving everyone a much bigger buffer for those smaller undeclared assets. Now, the timing here is absolutely crucial. So the official instruction from the CBDT came out on August 18th, 2025. But, and this is the important part, the legal change itself is effective retroactively from October 1st, 2024. This just means the enforcement policy is now officially catching up with the law that was already changed. Okay, but this relief from the threat of prosecution comes with a massive asterisk, a really important clarification that every single taxpayer needs to understand. This is not a free pass. So you might be asking, am I totally in the clear if my undisclosed assets are under 20 lakh rupees? Well, let me be perfectly clear. The answer is no, and here's why. This slide nails the difference. You have to separate the idea of a penalty from a prosecution. Think of a penalty like a monetary fine for breaking a rule, like a traffic ticket. Prosecution, on the other hand, is the serious stuff. That's a criminal proceeding, like getting a summons to appear in court. The new rule helps you with prosecution, but not necessarily with penalties. And the CBDT has actually connected the dots for us. Their official instruction basically says that if penalties under Sections 42 and 43 of the Act aren't applicable for undeclared assets up to 20 lakh rupees, then a prosecution under Sections 49 and 50 won't be started either. It just creates a nice, consistent approach. Okay, so we've gone through all the context. Let's boil this down to a simple, practical action plan. What does this all really mean for you? The big sigh of relief here is pretty clear. The risk of facing severe criminal action for a smaller oversight is way lower now. If you forgot to declare a small foreign bank account or a few shares, that constant fear of prosecution is significantly reduced. And that's a huge deal. But, and I can't say this enough, your legal duty to report everything has not changed at all. You are still required by law to declare all of your foreign assets and income in your tax filings, no matter how small they are. This new rule is a shield against prosecution, not an excuse to hide anything. So when you step back and look at the big picture, What the government seems to be doing here is making a strategic shift. They're trying to focus their heavy-duty enforcement resources on catching the big fish, the major tax evaders, while giving some much-needed breathing room for genuine, honest mistakes on a smaller scale. It's about accountability, for sure, but also about fairness. And that brings us to the final question we'll leave you with. With this new clarity, is everything in your own foreign asset disclosure completely up to date? This is the perfect time to review your filings. And look, if you have any doubt at all, talking to a tax professional is always the smartest move. This is a positive step, but at the end of the day, full compliance is still your responsibility.